the evidence. That sounds quite nice and Bayesian, doesn't it? And the factors of consequence in determining the action, obviously. And again, probative value is not defined. England, needless to say, does not have a statutory definition of relevance, but one of the classic statements is in Kilburn and DPP. Evidence is relevant if it is logically probative or disprobative of some matter which requires proof. Relevant, i.e. logically probative or disprobative evidence, is evidence which makes the matter which requires proof more or less probable. Now we can argue about whether you can make things more or less probable, but in other words, relevance and probative value are sort of conflated. They're just one question. The Australian Evidence Act is a bit different, and one might characterize this as a self-inflicted problem, but it actually creates some interesting issues for us to think about. In the Australian Evidence Act, and in the Northern Territory version of it, relevant is defined as evidence that, if it were accepted, could rationally affect the assessment of the probability of the existence of the fact in issue. And notice that we're now talking about affecting the assessment of probability, not the probability of a fact. So Bayesians would approve of that. And probative value is also defined as the extent to which evidence could rationally affect the assessment of probability of the existence of a fact in issue. So there's a key difference in the two definitions, which is that phrase I've highlighted, clause, if it were accepted. And the questions that arose on appeal, in this case IMM, and that's the citation 2016 HCA 14, heaven knows when it'll be out in the Commonwealth Law Reports because they're a bit behind. But you can find it on OSTLE or any of those databases. Are those two definitions different? These are the kinds of questions the judges ask themselves. If they are, should, if it were accepted, be read into the definition of probative value? And some judges thought yes, the evidence must be accepted to be of any probative value. So that clause should be read into the section. And some judges said no, we're dealing with different questions for the judge here. And some of these issues are set out at para 140 of the judgment. Now, some of you, who remembers the Dingo Baby case? Who's seen the film with Meryl Streep? Oh, I do recommend it. It's one of, if you're running especially a sort of postgraduate master's level evidence course, it's a great sort of team building exercise to have a sort of pizza evening and show that film amongst other possibles. But it's a great film that I recommend to anyone who's interested in evidence, statistics, forensic science, etc. On appeal in the Chamberlain case in the High Court of Australia, one of the judges said, it is an obvious proposition of logic that you cannot be satisfied beyond reasonable doubt of the truth of an inference drawn from facts about the existence of which you are in doubt. And, and what he was actually talking about was the finding of reddish stains in the Chamberlain's car, which had reacted positively to a test for blood. The problem was it was actually a test for hemoglobin and it reacted to the rust. So it was a non-specific test. So in fact what the judge was describing as a primary fact wasn't a primary fact at all, it was the product of observation and inference. And in a subsequent lower court case, a judge called Roden refused to follow the High Court of Australia's ruminations on this issue because he said that, first of all, it wasn't a proposition of law, it was a proposition of logic, and as a proposition of logic it was wrong. And he went on to say, playing that game, anything which was the subject of evidence could be reduced to a level at which the jury could be said to be satisfied beyond reasonable doubt, even if it be as basic a level that the witness said what is written in the transcript. Now, actually, here he has hit the nail on the head. And this helps us sort out the problem in IMM and the Queen and why the judges divided. IMM was charged with indecency and sexual intercourse with a step-grandchild between the ages of 4 and 12. And these charges dated back some considerable time. And the contested evidence was that the complainant alleged that when she and a friend had given IMM a back massage, he had run his hand up her leg. And this evidence was introduced to sort of show that he had sexual interest in her, although she, A, was step-grandchild and B, very young. The judge asked the question, the judge had to operate section 97.1, remember, that this evidence is of other conduct, showing that someone has a tendency, i.e. sexual attraction to this girl, therefore it's only admissible if it has significant probative value. And the judge assessed the probative value of the evidence on the assumption that the jury would accept the evidence. Yeah, the jury would assume, in other words, that the story was true. The question then is, what probative value is it? Well, let's have a think about this in formal terms. There we are. First of all, the prosecution hypothesis obviously is that the accused did the acts alleged. I don't like purely negatively expressed alternative hypotheses, but that'll do for now. The alternative hypothesis is you do not do the criminal acts alleged. W is a witness statement. Person standing in the witness box stating he ran his hand up my leg. And E, which normally stands for evidence, is the proposition that the accused ran his hand up her leg. Now, if you think about that, you just realize that there's actually three likelihood ratios of potential interest. There's the probability that he ran his hand up her leg given the prosecution hypothesis is true, against the probability that she did it given that the prosecution hypothesis is not true. Then we get on to W, which is the fact that the witness has made a statement in the witness box. There's the probability that the witness would have made the statement given that the evidence is true, and there's the probability the witness would make this statement given that the evidence, the story about the hand running up the leg, was not true. And then finally, of course, we've got the probability that the witness would have said that he ran his hand up her leg given that the chap's guilty, to use a shorthand, and the probability that she would have said this if he were not guilty. But these lead to rather different considerations, because if we say the criterion is to be operated assuming the jury would accept the evidence, we must be referring to the probability of E given H1 and H2. In other words, the probability that he did in fact run his hand up her leg given the two hypotheses. That's what the focus is on. But section 97.1 refers to the admissibility of the evidence of the conduct of a person. And the evidence of the conduct is the witness statement in the witness box. And that's the evidence that has to be admissible, that the judge has to consider the significant probative value of. So that means that the likelihood ratios of concern are to do with the probability that the witness would have made this statement, not the probability that he ran his hand up her leg, given the alternative hypotheses. And you can then set this out in a very simple Bayes network, or those who are familiar with Wigmorian diagrams, which are just Bayes networks with the arrows going in the opposite direction, really. And so I think I'm right in saying that, but we won't get too bogged down in that. Let's go on to the next one. We've got four sort of considerations here. What is the probability that the witness would have made this statement, that he ran his hand up her leg, given that the prosecution hypothesis is true, given that he did in fact run his hand up her leg, and I is everything else, all the experience and common sense and knowledge that David Bentley was referring to jurors having or not having, because all probabilities are conditional, and the probability of that tends to 1, I would say. What about the probability that the witness would make this statement given that Chummy was guilty, but he hadn't actually run his hand up her leg? Well, the probability of that must be above 0, I would suggest, gilding the lily.
What was he guilty of?
Indecent assault, rape, that sort of thing, yeah.
Rape?
Well, the minor. Sexual intercourse with a minor, yeah.
Well, intercourse?
Yeah.
Not just...
But as a different occasion from this.
Sorry?
But as a different occasion.
Yeah, different occasion. This was not a charged incident. This was simply introduced as evidence to show. And you'd think it would be of some use if the evidence had come from the other girl involved, but in fact it was coming from the complainant. So the probability of the second one I would suggest is above zero. There's some probability that Chummy is guilty and she wants to get him convicted, so she's going to gild the lily of the evidence a bit. What is the probability that she would make this statement if he hadn't actually done these things? Well, given the fact that she's made the charges and got it to court, again, I would suggest the probability of that is above zero. And then you have the probability that the whole thing is a complete setup. He didn't do it, this incident never happened, he didn't commit the acts alleged, and so forth. And again, that probability must be above zero. But the point is, and this is the question that the court in IMM were wrestling with, is that if we're going to consider either of these probabilities, it must depend on the credibility of the witness, the complainant. That obviously must be taken into account. Now, that brings us back to our definitions of relevance and probative value. And it makes me realize that, in fact, the definitions are about different things. The definition of relevance focuses on the content of the evidence. If this evidence, this content is accepted, would it be of probative value towards the ultimate hypothesis? And if so, it's relevant. But when we then come to consider the probative value, we've got to look at the fact that this witness made this statement and consider all the factors that apply to that. Now, this makes sense in a way, it seems to me. For example, if I say, I saw X run away from the scene, and X is the person charged with murder, you can't call that irrelevant, can you? That must be relevant. But if we're then going to decide what its probative value is, we're then going to look into my visual acuity, whether it was dark, whether it was raining, whether I know the person, whether I got a grudge against them, and all this kind of thing. So it does actually seem to be...
X was also in fear of his own life.
Well, yes. Well, there could be an alternative explanation for being the person running away. We're just talking about whether or not he was the person seen running away at this point. So it actually seems to me to make a sort of sense, and I don't know whether it's accidental, bearing in mind that this is Australia, but when we ask the question, is this evidence relevant, we're looking at the content of the evidence. When we're asking what is the probative value, we then start to look at the characteristics of the witness, the conditions under which the evidence was obtained, and so forth. So the central issue is actually the definition of evidence. What do we mean by evidence? Do we mean the person standing in the witness box testifying, or do we mean the content of what they are saying? And this point was missed in discussion, the whole discussion about whether this if accepted clause should be read into the section. So what we then have is two stages. Obviously the first decision any judge must make is whether evidence is relevant. And so this will apply to scientific evidence as well. So I am putting forward the proposition that at that stage the judge is considering the content of the evidence and whether it is capable of altering the assessment of probability of the final hypotheses. What the judge doesn't do at that point is consider all the aspects to do with the witness and so forth. But when you come on to probative value, now when does a judge have to do that? Well, a judge has to consider probative value under section 97. A judge in the end always has to consider probative value when it comes to balancing prejudicial effect against probative value, which is the sort of final stage of consideration of any evidence. And at that point, the judge, it seems to me, must be looking at the witness, their characteristics, incentives acting on them to lie, and so forth. Now this does actually have some quick reference to scientific evidence, because we're all too familiar with witnesses who state a conclusion of a hypothesis. So what are we going to do with that? And in fact, one of the classic examples in civil cases is evaluation. Because in a valuation case, the valuer stands up and says, in my opinion, this property is worth £1 million. And the valuer for the other side says, no, it's worth £2 million. And so the valuers there appear to be giving evidence of the ultimate issue that the court has to decide. What you have to do is focus on their utterance as the evidence. And you then ask yourself, what is the probability that this valuer would value it at £1 million, given his experience, knowledge, understanding of the area? Has he taken into account the fact that there are possums on the neighbouring land, etc.? And the same with forensic scientific evidence. If you get somebody stating an identification, one way to look at it is say, well, what is the probability that this witness would have stated this identification if in fact the traces have common origin and if they don't? And so that's a way of dealing with people who erroneously give statements of probability of the hypothesis. Now one could talk about various other issues, but anyway, my answer to the question of the week is any question that is related to determining the truth and does not require balancing truth determination with any other value is capable of probabilistic analysis. Thanks.
Thank you. That's excellent to have somebody directly addressing the question.
Bill.
In case law in the United States on evidence, a distinction is drawn between what U.S. judges have called logical relevance and materiality as two aspects of the overall concept of relevance or probative value. So logical relevance would be the ability of testimony to prove some underlying proposition, and materiality is the ability of that underlying proposition, if accepted, to prove some proposition of value in the case. And it seemed to me that the distinction you're drawing using your conditional probabilities is exactly that distinction that's traditionally been made by American lawyers between logical relevance and materiality. And I guess my question is this distinction not drawn in the Australian common law? And it seems to me that the problem that you're alerting us to is really a problem in the Northern Territory statute. The fact that it says that logical relevance is the probative value if accepted means that it's talking about what American lawyers would call materiality, which is only one aspect of the overall evaluation of the strength of the evidence for proving a proposition.
We always have to define these terms, and in the classic English usage, materiality tends to refer more to, is this a matter that legally has to be proved in order to prove the case? But people use, the trouble with these words is they get used to mean different things. Well, yes, in one sense this is a self-inflicted injury on the part of the Australians, the way they've drafted the statute. But it's actually caused me to reflect on this issue and come up with a scheme that 7 judges of the High Court of Australia failed to come up with, and that it does actually make a certain amount of sense. So obviously one of the problems with having an Evidence Act that defines these fundamental terms is you then have to start looking at the words of the Act. And that has, in fact, since the Evidence Act 2006 was passed, lawyers have started talking about relevance and probative value, which they never talked about before, because they're there in sections of the Act. So it's a bit of both, I think.
Yeah, also to talk about the American situation, I don't see the problem from the American perspective, and in fact think that the two phrases are right, because the way an American judge would approach this issue would be to say the question of the witness's credibility is for the jury.
Yes.
It's not for me to decide that issue. Ergo, while I may decide relevance on the notion the jury will accept it, when it comes to the probative value test for propensity evidence, what the judge should be thinking of is not, was this a convincing witness? That's a jury question. Should be, someone runs their hand up a leg in a massage, how prejudicial is that going to be? Does that really mean much? I mean, in a massage, you're kind of relaxed, your hands are lying back, etc., etc.
Yeah.
So it seems to me they got it right.
Well, the common law, what you're saying is absolutely right. But there is the twist here that section 97(1) says that the court must decide whether the evidence has significant probative value. And that must include the characteristics of the witness and so forth. So, and statutes can tell a judge they've got to think about probative value, even if normally these are matters purely for the jury.
I guess I wonder if that's not the problem that you're reading. I mean, you're the expert. I know nothing about it, so you're right, I'm wrong. But nonetheless, my wonder would be whether that is actually the way to read that statute. That when they say the judge must assess the probative value, they mean it's logical that how does it, not is this a witness was credible or incredible. A judge can do that at a certain level.
Okay. I don't know,
Yes,
quick
I
question
mean, just
from me.
the fact is that phrase is there, that clause is there in the definition of relevance, and applying the rule of inclusio unius exclusio alterius, it's not included in the definition of probative value.
Quick question. Can you put back your answer to the question of
Yeah.
the week? Well, quick questions. I don't understand part two. You say,
Oh.
so first of all, you say basically anything can be treated probabilistically.
That's related to determining the truth.
And what does part two mean? Does not require balancing?
Does not require,
Do you mean does require
what's happened
balancing?
to it? No, what I'm saying is that once we've determined the truth, this is not moving for some reason, we may have to balance truth finding against some other value, like the exclusion of illegally obtained evidence to protect rights and so forth. And that's not an issue that
So if you brought the
probabilistic
truth
analysis,
I see
Obtained
what
by
you mean.
torture,
Yeah.
that's a different question.
that's not an
Yes.
issue that probabilistic analysis
Okay.
casts any light on.
Okay.
Thank you. Thank you very much. Then.
Right.